welcome to the next session on culpable homicide and murder. Today we will discuss all the provisions regarding section 300. The section 300 is basically divided into 4 clauses. Clause 1 and section 299 para A is totally same. Where the person had the intention to cause the death of the person, we call it as that he actually committed the murder and punishable under section 302 of Indian Penal Code, either with the punishment of death or punishment of imprisonment for life. When we say that a person has committed murder, he may have degrees of variation of mens rea, but if he has committed murder, then he is punishable only and only under section 302, that is either by death or imprisonment for life. So a culpable homicide may amount to murder when it is caused intentionally as per 300 clause 1. But if there is no intention, direct intention to cause death of the person, but some other circumstances are present, then also a person can be said to have committed the murder. We will analyze one and the other provision one by one. Clause 1 has already been discussed in the previous session, so need not to discuss it again. We will directly go to clause 2. What does section 300 clause 2 says? It says, when a person by doing an act causes death of another person and that act was not intentional act, okay, that act was intentional act, that act inflicted an injury upon the body of the other person, that injury may or may not be sufficient in ordinary course of nature, or may not be likely to cause death of the person in itself, but that injury become fatal or deadly because of presence of some other circumstance. That circumstance aggravated the injury and caused the death of the person. Take for example, a person is suffering from a swollen spleen, abdomen, inside the abdomen, the blood carrying vessel spleen is swollen. Now if you will punch a person on the abdomen, it will not cause death of that person. Abdomen, it will not cause death of that person. And the injury which is being caused with the help of this punch is not even likely to cause death in ordinary circumstances. But in this particular case it caused death because the result of the injury was that spleen of the person's that bursted. Now that causes the death of the person. Here the injury was neither sufficient nor likely to cause death, but it resulted into the death of the person. How to find out whether the person is liable for murder or something else? Now if the knowledge was there to the person that he had a swollen spleen or some kind of disease which may aggravate the smaller amount of injury to the fatal injury, then that person will be held to be. For example, a person is suffering from heart disease. Second person gave a punch blow upon the chest of the person. Now the effect of the punch blow on the chest of the person is not a kind of injury which can cause death of a person. Neither this kind of injury will likely to cause death, is of not such a nature. But over here it caused death of the person because he was suffering from heart disease, and that particular punch proved to be fatal because of existence of those circumstances. In that case, person will be said to have committed murder only if he had the knowledge of that particular circumstance, only if he had the knowledge of that particular disease. Moving to the clause 3. Section 300 clause 3 is the most controverted section. Here it talks about the situation where a person caused bodily injury upon the other person. Now that injury was caused to the other person with the act of the accused, and that act was intentional act. So bodily injury, whatever is there on the part of the body of the person, is intentional injury and caused upon him by the act of the accused. One thing. Secondly, the injury which came on the body part of the person is of such a nature which is sufficient in ordinary course of nature to cause the death of the person. Take for example, if I kill a person with a knife in the abdomen, this is clearly manifesting my intention to cause death, which will be covered under section 300 clause 1. On the other hand, if I am having an iron rod and I gave a very hard blow upon the head of that person, here I don't have, this particular act cannot manifest the intention, but it shows that I had the intention to cause an injury. Now the subject is to find out what kind of injury it is. That we can find out by looking at the circumstances, for example the injury itself, or by looking at the medical report by the expert. Expert opinion can be taken over here, allowed by Indian Evidence Act, to find out whether this injury is sufficient in ordinary course of nature to cause death or not. In case of Virsa Singh versus State of Punjab, 1958 Supreme Court, the Honorable Supreme Court discussed when a person can be said to have committed an offence under Section 300 Clause 3 and laid down certain guidelines to find out whether he is punishable under Section 302 or not, read with Section 300 Clause 3. So these are certain guidelines which we have already discussed, and let us read once again. First one is, accused has caused a bodily injury on the body of the deceased. This is very much clear from the fact that the injury must be intentional injury and caused upon the body of the person by the act of the accused. Second is there, it must be proved by direct evidence that it is the accused that inflicted the injury. So there must be a proof that this was the act of the accused which caused the injury. Third is that accused intended to cause the same injury which is the cause of death. Now this is important. If there are multiple injuries, some injuries were caused by the accused and some by some other reason, there must be ascertainment of the fact that the injury which were caused by the accused are the reason of the death of the victim. And this must be specifically proved by the prosecution to establish the culpability of the person under Section 300 Clause 3. The injury inflicted is sufficient in ordinary course of nature to cause death. It must be proved that the injury which is on the body part of the person must be sufficient in ordinary course of nature to cause death. If it is not sufficient, then it may be either probable or likely to cause death and will be punishable under Section 299 Clause 2. On the other hand, here we are talking about a kind of injury which is sufficient in ordinary course of nature to cause death. For example, I told you a very young man gave a very heavy lathi blow made of iron on the head of an old man. Now what happened? This resulted in fracture of the skull of the person. You can easily ascertain that this kind of injury is sufficient in ordinary course of nature to cause death, and the person will be liable for the murder. How to ascertain that an injury is sufficient in ordinary course of nature or not? The very best evidence is to find out from the medical report. Seek the opinion of the expert whether the injury is sufficient in ordinary course of nature to cause death or not. Other things which we can see is nature of injury. If the iron rod is there, person is very healthy person, other person is a weak person, the nature of injury that I have caused it on the head of the person will tell us whether it is sufficient in ordinary course of nature to cause death or not. Number of injuries. Now the rod was not iron rod, it was made of wood, but I gave multiple blows on the head of the person, caused a very severe injury on the head of the person. Now these multiple blows will definitely give the inference that this injury is sufficient in ordinary course of nature to cause death. Let's take another example. Few persons decided to loot a vessel, a ship you can say. They landed upon the ship and one of them had the uniform of the naval officer. They were not having the other uniform. So one of them, he kidnapped a naval officer, tied his hands with rope and legs, put some adhesive on his mouth, closed the mouth, and put the chloroform soaked cotton into the nostrils of that particular person. Victim died because of this. Now the question was whether this is murder or culpable homicide not amounting to murder. In this case, Supreme Court said the act of the person which cause the injury to the other person is sufficient in ordinary course of nature to cause death, and hence he is liable for murder. The celebrated case was Rajwant Singh versus State of Kerala, 1996 Supreme. Up till now we saw that a person can be held liable for murder if he caused the injury intentionally. What if the injury caused upon the body of the person is not intentional? Then can he be held liable for murder? Yeah. There is a provision under section 300 clause 4 that if the injury is caused by an act which is very dangerous, but the injury is not specifically intended to be caused upon that person's body. Take an example. To understand it better, take an example. Say for example, a soldier had a cannon and he fired that cannon without any justification towards a mob. Now here, he does not intend to cause injury to X, Y or Z who were the victims of that fire and died. But the act is very dangerous in nature, and it can be said that in all probabilities it will always cause death of some person. Here he must be liable for murder because his act was so dangerous that in all probabilities it will cause death of some person. So section 300 clause 4 can hold him liable for murder. There are certain exceptions to this rule, provided that he must not have committed that act under some lawful justification. That the act must be very dangerous in nature. Dangerous must be up to that extent that you can ascertain that death in all circumstances will result. There is a very high probability that death will be resulted from such kind of act, and actually death has been resulted from that particular act. Then we say that this person has committed the offence under section 304. So this was regarding the discussion upon section 300, where we found when a person will be liable for offence of murder. There is another kind of culpable homicide where the offence of murder will be converted into culpable homicide not amounting to murder due to presence of certain circumstances. Those circumstances are exception to section 300. There are 5 exceptions to section 300. Even though the offence is murder, but due to presence of those circumstances, its punishment will be reduced to culpable homicide not amounting to murder, and he will be punishable under section 304. The burden of proving the exception lies upon the accused, and he will have to prove the existence of those situations. Based upon the collaboration of act and intention, we can say there are basically 6 kinds of punishment and 6 kinds of culpable homicides. First one is murder, where there was intention to cause death of the person. Second one is murder, where person had the knowledge of certain special circumstances and intention to cause bodily injury. This is again punishable under section 302. Third is kind of murder, where the person had the intention to cause bodily injury and that bodily injury was sufficient in ordinary course of nature to cause death, and that is again punishable under section 302. Kind of murder, where his act was so dangerous that in all probabilities will cause death, and it will be punishable under section 302. Fifth is a kind under section 299B, where person had the intention, but intention was to cause the bodily injury, and such bodily injury is only likely to cause the death, and it will be culpable homicide not amounting to murder, that is punishable under section 304 part 1, because the death was caused because of injury. Sixth one is 299 part C, where he had the knowledge that his act may likely to cause death of the person, but his intention was never there to cause the injury which caused the death of the person. So he will be liable for culpable homicide not amounting to murder under section 304 part 2. And if the intention is below section 299C, then he will not be liable for any offence of murder or culpable homicide. He may be liable for hurt or grievous hurt. In our next session, we will examine all the exceptions regarding section 300 and when presence of an exception may result into conversion of murder into culpable homicide not